Cross case people versus Elton Bell.
Good morning, Your Honor.
Inbeatme Abu on behalf of Mr. Bell. Mr. Bell, can you please state your name for the record?
Elton Robert Bell.
And good morning, sir. All right, what are we doing?
Your Honor, I did submit a green form, but we are actually not going to be adjourning on this case. We are going to be waiving preliminary examination.
All right, Mr. Bell,
Yes.
you're going to waive your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
And you understand you'll not have that hearing. You'll proceed to circuit court for further proceedings.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over on a single count.
We waive formal reading of the charges and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 28th, 2025 at 1:30 with Judge Slay.
August 28, 2025, 1:30, Judge Slay.
Thank you so much, Your Honor.
Thank you, Your Honor.
Bond will, thank you, sir. Bond will continue. Court calls case, people versus Ardean Henderson.
Hey everyone.
Inbeatme Abu on behalf of Ms. Henderson. Ms. Henderson, can you please state your name for the record?
So my name is Ardean Beatrice Henderson. Grand Rising. Thank you all for having me.
You're welcome.
Your Honor, we are going to be asking for an adjournment. We have just started a mitigation process. So we're going to be asking for an adjournment for that purpose and plea negotiations.
Your Honor, I would just remind the court, this Tingley does have a case in Wayne County. She's got a case at 35th District Court, where she's referred for competency in May. That court has not come in based on restoration actions. And that court is for August 29th.
August 29th. So were you aware of that, counsel?
Yes, I was. She had told me that she started that process.
Okay, well, then I'm a bit reluctant to do anything prior to that competency report coming through. So
Are we able to adjourn further out?
I'm able to do a lot of things. Some of the things I will not do.
Whatever Your Honor prefers.
Of course, you're learning. Give me a September date.
September 11th.
September 11th.
Can she hear us?
I will adjourn. Yeah. Can you hear me, ma'am?
Yeah, I just don't understand what's going on. Can somebody please explain to me, please?
Okay, so I'm adjourning it out. Okay, my understanding is that there's a competency review in your other matter.
Okay.
Okay, so
Okay.
what we're doing is we're taking the safe course of this, putting this out till after there's a finding there, because that may dictate what happens here. We really can't get much done until that comes through.
Okay, well, my lawyers better explain to me later also again, I won't forget. Or can someone send me something or something if I can have someone read to me what's going on? Okay, never mind. The sergeant here said, Sergeant Perzon, how you pronounce your name? Porzondek said he'll help me. He explained to me.
Okay, and your attorneys will be in touch with you, okay?
I can talk to you next week, Ms. Henderson, okay? To explain all of this.
Thank you.
Okay.
I thank you all for having me.
Yes.
Okay,
we are so glad, and we will have you
you
back in September 11th, 2025 at 9 a.m., okay?
Take care, Ms. Henderson.
Bond
For
continue.
my birthday, and what day would
That's your
what day
birthday?
would that be?
September 11th.
September the 18th. It's right before.
September 18th, your birthday? Well,
Maybe
so I
Yes.
don't forget, happy birthday.
Thank you. I'm taking my grandkids to the water park before it gets cold. Thank you.
Okay, take care.
Thank you.
Does call the case of the people versus Nathan Bell.
Assistant Public Defender Nick Bukovich for Mr. Bell, who should be appearing via Zoom.
Nathan Bell, do we have him?
No, I do not.
I was in contact with my client this week and he asked me to put in that Zoom request.
He did?
Yes.
I'm here.
So,
I'm here.
He goes by another name, Motorola. Sir, I
Yeah.
need you to turn on the camera, please.
Yes, sir. Yes. Am I here? Yes, I'm here.
Okay, you have to uncover the lens. There you go.
there you go.
What's your name?
Nathan Bell.
All right, what are we doing?
I'll be requesting a brief adjournment for Mr. Bell to obtain some medical documentation I can provide to the prosecution towards an offer. And I do have a green sheet, Your Honor.
July 31st, 2025, 9 a.m. Bond continued. Court does call the case, people versus Jonathan Miles. Oh, there she is. Okay.
Good afternoon, I'm sorry, good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning.
And Alex Warren Green on behalf of Mr. Miles. Mr. Miles, can you state your name for the court?
Jonathan Dion Miles.
All right, what are we doing?
Your Honor, I had an opportunity to confer with the Assistant Attorney General. She did extend a generous offer, but at this time, Mr. Miles is asking for a preliminary examination.
I'm sorry, who in our office did you speak to?
I emailed you, Ms. Williams, and received a return email as well.
Okay. I don't recall that, but okay, I'll look through my emails.
All right. You want this set for exam?
Mr. Miles is asking for a preliminary examination, yes.
All discovery is complete.
Believe so, Your Honor.
Would the people have their witnesses available on the 22nd?
We should, Your Honor. I'm sorry.
All right.
What is the defense attorney's name? He's saying he sent this email. I don't remember having a discussion. Was this shortly after the last hearing about this case? I know we hadn't made an offer at the last hearing.
My name is Alex
Yes.
Warren Green.
Okay. I'm not saying that you
received a
did.
Yep.
No, I get you. How much is owing on this?
Your Honor, I believe it's just north of $6,000.
And so the exam is going to be over what's owed?
Your Honor, I
Might
might
mean the law that if it's charged, it's owed.
talk to my
That's
client.
okay.
I advise him of the
We'll
law,
set
I
it.
advise him of the offer.
We'll set the exam.
Thank you.
Preliminary examination in this matter in person will be set July 22nd, 2025. That's at 12 noon. And that's before me.
Thank you, Your
So if
Honor.
we set it for exam, Mr. Warren Green, you better come with something.
Thank you, Your Honor.
Court calls the case, people versus Daniel Bowe.
Assistant Public Defender Nicholas Bukovich for Mr. Bowe, who is approaching.
Your name?
Daniel Bowe.
Thank you.
At this time, Your Honor, be requesting a brief adjournment. The prosecution has extended an offer. It's just Mr. Bell wants to confirm that this offer won't have impact on an outside matter before accepting it. So,
Probable cause conference, July 22nd, 2025, 9 a.m.
Mr. Bell did want me to ask if we could do a possible further out adjournment because he'll be up north for work from July 19th to August 5th. I did explain to him I could ask that, but it's ultimately up to the court.
Yeah, I'll be up by Mackinac working for about 2 weeks. And I don't want to miss court and have anything come back on me because I'm 4 hours away. If I have to make that adjustment, I will, but I'm just asking.
Oh, I know. When are you coming back now?
August 5th, I'll be back.
Any objection from the people?
No, Your Honor.
Thank you.
August 7th, 2025, 9 a.m.
Thank you, Your Honor.
You're welcome. Bond continue.
Thank you, Your Honor.
Calls case people versus Noah Adamson.
Lord Yagi, Assistant Public Defender, with and on behalf of Mr. Adamson, who's approaching. Could you state your name for the court?
Noah Adamson.
Thank you.
Your Honor, we are respectfully requesting an exam be set in this matter. The only
All
outstanding,
discovery, go ahead.
no, I'm sorry. The 911 call has already been requested and should be here either today or tomorrow.
That's correct, Your Honor. And if we could address it on appropriate.
Preliminary examination in this matter will be set July 22nd, 2025, 9 a.m. That will be before Judge Barr. As to bound.
Your Honor, it's come to my attention that since arraignment, the defendant has made 37 calls to the victim in this case, and at this time we would be asking that his phone privileges be revoked.
Where'd you go? Oh, no. Response.
Your Honor, unfortunately, we don't have, the calls, we don't have the timings. I can't really respond without having the information underlying the argument. Mr. Adamson actually wanted me to make a bond argument today for his release, as this is the only case holding him, and he has to go back to work. He has a separate residence from the alleged victim. I will have a conversation with him about ensuring that he understands and will comply with the no contact order. I know he's been contacting his family and friends using the phone here, as he has a lot of kind of business to attend to on the outside, and his rent's coming up and all that. So I would ask for the court to reserve judgment until the exam date in terms of his phone privileges.
These are to the victim's number.
Your Honor, I believe so, Your Honor. Yes.
They are. So, Ms. Yagi, are you making a motion to reduce his bond? I mean, was that what I was hearing or not?
I am, yes.
Go ahead, response.
I would object, given the phone calls. I believe the defendant is also currently on probation for a previous conviction in circuit court for a GBH DV act with the same victim that he was sentenced on, I believe, in February of this year. In this case, they had an argument. He grabbed her by the wrist, pushed her up against the wall. She was able to free herself, tried to use a roommate's phone to call 911. He takes the phone, hangs it up. She then tries to call 911 from another phone. He then takes that phone, hangs it up, and he entered the apartment to begin with without permission. I have concerns given that he is on height of probation for a DV offense with the same victim from this year and is engaging in that same behavior. Would ask that bond remain the same.
Anything else?
I just want to note that that there's no hold for that case, and we discussed the tether. He's in accountable choices. He's in contact with his probation officer and hasn't been violated yet. So, but nothing further, Your Honor.
Defendant's motion for bond reduction is denied. As to people's requests as to the revoking of his phone privileges, this time the court will revoke the defendant's phone privileges. Defense is entitled to and can request a hearing on that matter once they hear the calls.
Thank you, Your Honor.
Court calls the case People versus Matthew Fonseca.
What's the deal on this one?
So he has a bond violation. This one. Oh, I'm sorry.
That's
Good morning, Judge.
good morning.
How are you? Brian Bowling.
I don't know. What are you gonna do? No, go ahead.
Good point. Brian Bowling on behalf of Mr. Fonseca, just state your name for the record.
Matthew Fonseca.
Your Honor, when it comes to the PCCs, We were in the process of trying to reach a global resolution, but now it's come to my attention, there is a new charge that we
Yes.
will kind of throw into that pot to try to
Yes.
put together.
Absolutely, and I'll arraign him on that charge. Mr. Fonseca, you're here on another case. If I can
Your Honor.
find my complaint.
I was able to obtain a copy of the complaint this morning. I did review that with Mr. Fonseca, so for purposes of the arraignment on that charge, I would waive formal reading and stay on mute.
Mr. Fonseca, you understand the nature of the charges in that case?
Yes, sir.
You understand the maximum penalties?
Yes,
And you do wish to be represented by counsel?
yes.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. So in terms of setting the probable cause in this matter.
Well, Your Honor, this would be, I guess, now 2 felony matters. It looks like that would be pending.
How come this doesn't have to do a date?
This is the one I found online.
Okay. All right, go ahead.
We do have the bond violation as well. That
Yes.
was alleged. I guess obviously,
Which are different than the new charges.
correct.
But
So, I mean, I guess if we just could keep everything together and have a
Yes.
couple weeks, I think that would be satisfactory. I should be able to get a discovery request submitted today, and hopefully we'll have those materials prior to the next.
I'll
meeting.
adjourn then everything. I'll adjourn the one that's set for PCC as well as the bond violation hearing. I'll adjourn that to the 22nd, 2025 at 9 a.m. Bond will continue on that matter. On the other matter, I will set the probable cause conference for July 22nd, 2025, 9 a.m. His bond in that case. What's his bond in the other one? So how many cases is he being held on right now?
It is just the bond violation, correct? Because you were out of custody, right?
Yes. Bond in this case will be set at a $5,000 cash surety at this juncture. I'll order standard conditions, including no assault, possession of any weapons, no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I will order that if the defendant is released, he is to report over to community corrections for 2 times per week drug testing.
Thank you, Judge. Your Honor, on the matter pending with the bond violation, was bond revoked?
It was.
Okay, thank you, Judge.
So his bond will be revoked on that matter. Correct.
Okay, what time do I go back?
Court calls the case People versus Robert Gallet.
Kerma Dadush on behalf of Miss Gallet on the case ending in 713.
Morning, Roger Kilwell, Judge. I'm on case 5612.
All right.
Your Honor, we were going to be asking for adjournment in our case and a chance to address bond, please.
You're also asking for an adjournment.
Yes, I'm sorry.
All right. Go ahead and address bond.
Thank you, Your Honor. First of all, Ms. Gallet here wanted to apologize for missing her last court hearing. Since the start of this case and since her last court date, a lot of things have changed. Ms. Gallet has, first of all, now she has a phone number, a phone that we can contact her on. She has gone back on her medications. She has bipolar medications that she has to take, as well as hormones. So all of that kind of, well, it can, no, I don't want, let me word this correctly. All of that is helping us reassure, we're using that to help reassure Your Honor that she is going to show up if she is released on her own personal recognizance. She has also, she has 2 different caseworkers helping her. She has a CMH caseworker and a PATH caseworker. She has been approved for Avalon housing if she were to be released. So all of that combined, her having a more secure home, having a phone number and medications. We are hoping to get a personal recognizance for that reason. She will appear. She has no intent, and there is nothing else holding her. I believe she has a 15th district court case, but that she has a PR for that.
How did she come back in custody?
On the 15th case, Your Honor, 15th district court case, which is just a parks violation.
When did that happen?
I believe on the 4th or the 3rd, July 3rd. Well, that was the day.
So between March 20th and that time, what was she doing?
She was unmedicated. Her husband also has bipolar and schizophrenia. They were both unmedicated. They were both homeless, doing quite poorly. Since then, all of that has changed. Her husband is in custody, but she is really trying to do her best. She, picks up debris with the Parks and Recreation program, Give 365. Again, her meds are a very big part of her ability to, come back to court and be more stable, have stable housing. And she hopes to even start classes with Washington Community College, wants to do linguistics, just wants to start becoming better. And her meds was the first step to that, Your Honor.
Mr. Kilowald, anything?
I would just echo that argument, Your Honor.
Anything from the people? I really don't necessarily need it, but go ahead.
Two sets of concerns. I appreciate that it sounds like there's some progress being made. That case in the 15th district is an assault and battery at Devon Hospital. I understand that things have happened in the psychiatric environment there, but that is just June 28th. And I'm concerned about some of the behaviors there and wondering, it sounds like there's been a very dramatic turnaround within a very short amount of time. I don't know if Mr. Lucia has anything else to provide proofs of some of the housing. Gallet is apparently of the California area, doesn't really have any ties to our county either. So I'm not sure. I'm not sure that we'll see her, quite frankly. If we do have.
So when I say I don't need it, what does that mean to you?
Well,
go ahead. No, go ahead. I'm listening.
I had options. You told me to add.
No, I didn't.
Although you don't need it. So, that's it.
Thank you. Motion for bond reductions denied. Bond will continue. I'll set the probable cause conference for July 22nd, 2025, 9 a.m. in both cases. Thank you. Court calls the case People versus Heresca Dennis.
And I'm on behalf of Mr. Heresca Dennis, who is approaching.
Again, Your Honor, Christina Costantino appearing on behalf of Mr. Heresca Dennis in the case number ending in 5076.
All right. Your name, sir?
Zachariah Heresca Dennis.
Thank you.
We're respectfully requesting an adjournment in this matter. We AIM sent over a mitigation report last night, and the prosecution needs time to review it.
And I would join in that request.
All right. Will the 22nd work? I think that's what we set your last case, Ms. Constantine. Is that right?
Yes, Judge, I would ask for the 22nd, given he is in custody.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond will continue. And Ms. Constantino, I will tell you, I miss you too. And Mr. Allen told me I wasn't very nice in saying what I said the last time. So I don't know what's going on there, but he was kind of yelling at me.
Well, thank you, Mr. Allen, and thank you, Judge. I appreciate you changing your mind. I hope to see you soon.
Yes, ma'am.
Thank you.
Thank you. Court calls the case People versus Christopher Cummings IV.
Assistant Public Defender Chelsea Vergils with and on behalf of Christopher Cummings. Please state your name.
Christopher Cummings.
Your Honor, we are requesting an adjournment today. Since his last court date, we did receive discovery. We're asking for time to review that and consider the offer that's been made in this case.
July 31st, 2025, 9 a.m. Bond continue. Thank you. Court does call the case People versus Mark Hubbard.
Alexander on behalf of the people, Your Honor. And back on behalf of Mr. Hubbard, who is approaching, Your Honor. Please state your name for the record.
Mark Hubbard.
Your Honor, at this time, we respectfully ask to set this matter for a preliminary examination and all discovery is complete as far as we are aware.
People have their witnesses available the 22nd.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 22nd, 2025 at
12 p.m.
12 noon before me. Bond will continue.
Judge.
Court calls case People versus Devon Julia Martinez.
Stephanie Cannon on behalf of Ms. Martinez, Your Honor, who is appearing via Zoom.
Devon, can you state your name for me?
Devon Julia Martinez.
Thank you.
Your Honor, Ms. Martinez was recently, I believe a week or two ago, evaluated by the Forensic Center because in her other cases, she has forensic order requested. I am filling out the paperwork to get one filed in this one as well. However, we have not received the evaluation back. Upon receipt of that, my client is indicating she does want to waive. However, I don't believe the court will do anything.
I won't.
But I want her to hear that, won't be able to do so.
When is that other case set? Do you know?
She is set in front of Judge Hamoud. I believe her next court appearance is on July 28th.
All right. And you're filling out the paperwork because you want, all right.
I'm just gonna have the order placed in this file as well, Your Honor.
So I will order a forensic evaluation. I will set her comp hearing on this case, October what?
October 9th.
October 9th, 2025 at 9 a.m. If the report comes in before then, certainly we can move that date out. All right.
And I will explain that to my client, Your Honor.
All right. Bond will continue.
Thank you.
Yes. And when they get that. Who's filling, thank you. Who's filling out the order? I can really? Oh, it's gonna be a minute here. Why is that taking so long?
Your Honor.
Why, not you, her. What is she doing? What, you trying to help her? Just slowly though, right? Court calls the case People versus Sean Hartman. Good morning. What? Hold on. So why are you with Douglas? Wow. I asked the question. Actually, what I was gonna say, what's Zenda do to you? Oh, okay. All right. No, I thought you might have requested a transfer. Permission to practice is granted. Go ahead.
Good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Hartman. Mr. Hartman, can you please shake your hand, let the deputy know need to be unmuted and state your name for the record.
Oh, yeah, hold on to that blanket. Don't worry about it.
Okay, thank you. Your Honor.
That's him. We're good.
Your Honor, at this time, we are requesting a brief adjournment. There is some outstanding discovery that I will need to get and review with my client. So we are just asking for an adjourned PCC date.
All right. Probable cause conference, July 22nd, 2025, 9 a.m. Bond continues.
Your Honor, may I briefly address bond?
Sure.
I did tell the people I was going to be doing so. Mr. Hartman's bond is currently set at $1,000, 10%. So $100 is what would need to be posted. I'm asking Your Honor to consider reducing that down to a personal bond. This case the incident date is from November 2nd, 2023. The warrant on this case wasn't signed until September 26, 2024. And then the arraignment on this happened on 6/30/2025. He's actually currently in Judge Conkey's drug treatment court. So this isn't a new case. It's not a violation, or I guess I should say it wasn't a violation. It will be if he pleads up, but it's not new. So I'm just asking for your honor to consider reducing it down to personal bond. He does have stable housing.
Is this the only thing holding him?
Yes. After this, Judge Kunke isn't addressing the bond on that case until this bond's addressed. So he has court on that on the 20, is it the first?
So
I believe on the 22nd.
Well, is this a bond violation?
I think at this point, since it's been issued, yes, but she was waiting to see what the court was going to do on this bond before she addressed her bond. He had court earlier this week.
Okay.
She put it out for us to address it here first, and then she's going to address it in her court.
Okay, just so that I have the timing correctly. He was in drug court.
Yes.
This case, the allegations in this case occur.
They occurred prior to him going into drug court. So this case, it took a while for the warrant to get signed. When the
Gotcha.
warrant
Okay,
got
that's what I
signed,
was trying to make sure of. So
yeah,
this case, I'm not clear how it would be a violation. Okay, I get you. That's what I was trying to figure out.
Yes.
Dates weren't matching up for him.
I think and technically it can be, but I don't think it's going to be viewed as it since the incident happened prior.
Any response from the people?
It's usually that it's a mobile case, it's not assaultive, so we would leave it in the court's discretion. The incident does predate the other incidents in the circuit court cases, and actually isn't showing any hold on.
Alan, doesn't she seem much nicer since she's not with Zenda? I say that out loud. I'm sorry, Miss Zenda, I didn't mean it.
They call your case or no?
All right, here's what I'm gonna do. I will, under the circumstances, and since he's in drug court, I will grant the defendant's motion. I'll reduce his bond to a $1,000 personal recognizance bond with all its conditions of no drug use.
Thank you, Judge.
All right,
2 minutes thing.
all right.
Thank you, Judge. I'll see you on the 22nd.
Thank you.
Have a great day, Judge. Have a
You
great
do
day
the
to staff
same.
as well.
Okay, he's all set. Court calls the case, People versus Nicole McCauley.
Maybe it Richmond, good for people.
Hannah Mackey on behalf of Mrs. McCauley, who is approaching.
So in there, you don't have.
Nicole McCauley.
Yeah, you're all set, sir.
We're requesting an adjournment in this matter, Your Honor. We are waiting for media discovery.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continue. Court calls case People versus Stefan Wayright. Why do I have so many down there? Jim?
And Alex Warren Green on behalf of Mr. Wainwright, who is on Zoom, Your Honor. Mr. Wainwright, can you state your name for the court?
Yes, Stefan Dallas Wainwright.
Thank you. Your Honor, I've completed an adjournment request form. We are asking for an adjournment to continue our negotiations with the people.
July 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court does call the case People versus Inbeatme Abu. Is it Agbu Zulu?
Alexander, on behalf of people, Your Honor.
Stephanie Canna on behalf of Inbeatme Abu.
Oguzulu Alexander.
Your Honor, the E is silent in his name.
Okay.
Yeah, let you know. Oh, Your Honor, we are adjourning this case.
Why, you know what?
For mitigation purposes, I do
I only
understand.
deal with her one day a week.
You got lucky. this
One
week.
day,
You got-
one day, and then you were here 2 days.
You got lucky.
So I'm over it.
There you go.
And Your Honor, if we could address it on.
And Your Honor, we understand he also has a bond violation.
Yep. Go ahead, Ms. Senda.
Your Honor, this would be a further violation of his bond as he third parties from the jail, and I will just paraphrase one of these conversations. As long as she doesn't show up, then they'll just knock the case out. All right, do you want me to tell her not to show up? Well, she already said she's not. All right, I might shoot a text and say, hey, don't show up to that court thing. He says, no, I think you should drive there. Ain't nothing wrong with you going there. He says, all right, talk to her in person. So I have concerns he's calling third parties, having them talk to the victim, go to her residence, see her in person to tell her not to come to court. And I would be asking that his phone privileges also be revoked.
Any response?
Your Honor, I have talked to my client about that. I was informed that this did happen. I actually don't have a copy of those. However, I trust that the prosecutor's office will be sending me those. Your Honor, my client is understanding that he cannot do that. He will not be doing that. And he is asking that his phone privileges remain in place. As to the prior violation, Your Honor, my client works for the property management. That's how they have the apartment that they live in. So on that date in question for that particular violation, he did not go to the resident. He was not in the residence. He went to the shed, we'll call it a shed, located on the property. He retrieved his tools and then he left. So
He could have done that with a civil standby.
he didn't go into the apartment, Your Honor.
Yeah, but I'm real concerned right now because the phone calls clearly indicate an attempt to get in contact with this victim, and then he's in the vicinity violating his condition. But you can go on if you wish, Ms. Camp.
No, Your Honor, I believe the court has all the information they need.
His bond in this matter is revoked based upon the bond condition, and his phone privileges are also revoked.
Thank you, Your Honor.
Thank you.
Oh, thank you, Your Honor.
Your Honor, what was the new date?
Was that it? I did not. You're looking for an adjournment. Probable cause conference, July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Court does call the case People versus Ryan Piper.
And Alex Warren Green on behalf of Mr. Piper. Mr. Piper, can you state your name for the court, please?
Ryan Piper.
Your Honor, today's date and time for a probable cause conference. In light of Mr. Piper's restoration to competency, I would be asking for a preliminary examination in this case.
Discovery is complete then.
Believe so, Your Honor.
And would the people have their witnesses available the 22nd?
Yes.
Preliminary examination in person, July 22nd, 2025. That's Barr. 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Barrage Scott.
And Assistant Public Defender Shanazi Carey, I can rule, Your Honor, on behalf of Mr. Barrage Scott.
I didn't know if you were going to do anything today other than that order that was taking forever. All right.
That's two things. State your name for the record, Mr. Scott.
Barrage Ante Scott.
Thank you. You're welcome. All right, what are we doing on this?
Judge, I have a green sheet. We are currently working on mitigation for Mr. Scott, so we're asking for an adjournment to continue that.
All right, so you're working on the mitigation.
Yes, Your Honor.
What do you have as bonds? I can look at it, that's all right. I'm just trying to think, how much time are you gonna need to?
I think the 31st should be fine.
Should be okay.
Yes, Judge.
Probable cause conference, and I'm good, Ann. To July 31st, 2025, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
Calls the case People versus Devon Haywood.
Inbeatme on behalf of Mr. Haywood, who is approaching to my right. Please state your name for the record.
Good morning, Your Honor, Devon Haywood.
Thank you.
Your Honor, I believe we reached a resolution in this matter.
You have. And it's here.
Perfect.
That's right. This is the one that, hang on a second, this one, sure, this is the one that I looked at. All right. We have a plea form in this case that the defendant would be pleading to the charge of use of a controlled substance. I don't have, how come these forms aren't that hard to fill out?
Pardon?
How come I don't have the maximum penalty on here of what he's pleading to? Who did this? Mr. Childers? Mr. Childers, type. Childers, you know what? No, you know what? It's typed. Did you type it?
No, I did.
You didn't. Who did?
It was a group effort, but I'll take.
I appreciate Ms. Mackey because she provided me with the basic flow. This is I think we're both at fault here.
It just felt.
Provided me with a mostly typed out plea form. All I did was look at it, sign it and send it back to her.
Because if it was up to me.
I fill these out myself.
Correct.
I appreciate Ms. Mackey doing my work for me. I'm not gonna, stop there.
Well, she half did it.
Yeah, and so we will.
I wasn't going to put a max penalty for my client.
What?
It felt wrong to like do that part. So I was like,
that hurt. I just couldn't write that. I couldn't type that part. What is the maximum penalty on the one? Pardon?
1 year.
1 year, 2,000. It was a group effort. I like how they all sat there and tried to protect each other. All right. May I have him sworn?
Solemnly swear in affirmative testimony you're about to give the truth, the whole truth, so help you God.
I do.
State your name.
Devon Haywood.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that, sir?
I do, Your Honor.
Do you understand what a no contest plea is?
Yes, I do, Your Honor.
All right. Two things about it. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I understand.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
I do.
All right. Basis for the no contest plea?
civil liability, Your Honor.
All right. And sir, to this charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct, sir?
Yes, sir, Your Honor.
You have any question regarding any of those rights?
No, sir, Your Honor.
All right. Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am. I'm on probation for. Explain the case.
Well, were you on probation at the time of this offense?
No, Your Honor.
All right.
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
And of your own free will?
Yes, Your Honor.
All right. The court has been provided Washington County Sheriff's Office report, and I've also reviewed that report for their case number 24-42704. Any objection to the court having reviewed that report?
Okay.
None from us, Your Honor.
All right. Sir, you also understand that if between the time I accept your plea, if I accept your plea, and the time of sentencing, if you commit misconduct as defined by the court rule, two things would occur. You would not be entitled to set aside your plea, and the court would not be bound by any sentence agreement and or evaluation of your case. You understand that, sir?
I do.
All right. Based upon the review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt. Before I accept his plea, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Not be up to people.
None, Your Honor.
All right. Court will accept the defendant's plea of no contest to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
August 14th, 2025 at 10 a.m. in Judge Washington.
August 14th, 2025. What time?
10 a.m.
10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you. Thank you, sir. Court calls case People versus Michael Frasier.
Assistant Public Defender Jay Bellinger on behalf of Mr. Frasier, who appears via Zoom. Mr. Frasier, can you please state your name for the record?
My name is Michael Valentino Frasier.
Thank you.
Your Honor, I am just asking for a 2-week adjournment on this matter. An offer was just made to me. I'd like time to discuss that with Mr. Frasier to see what he'd like to do.
Probable cause conference, July 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Court does call the cases of the People versus Bryce Valero.
Roba Handen on behalf of Bryce Valero. Can you please state your name for the record?
Bryce Valero, Your Honor.
Your Honor, we're requesting a two-week adjournment on this matter for negotiation purposes.
Probable cause conference will be adjourned. July 22nd, 2025, 9 a.m. Bond in each of these matters will continue.
Sorry, am I done, Mr. Simpson?
Oh, yes, sir. You're good, Mr. Frasier.
Okay.
Thank you
appreciate
for
it.
waiting and asking.
Yes, sir. Thank you.
Your Honor.
Thank you. Thank you. Court does call the case People versus Srano Johnson.
Assistant Public Defender Chelsea Vergils with and on behalf of Srano Johnson. Mr. Johnson, please state your name.
Cyrano Johnson.
I mispronounce your name every time, sir. Okay, I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with his bond conditions. I understand he's had a violation that we are prepared to deal with today.
All right.
Mr. Johnson is prepared to plead guilty to violating his bond by consuming alcohol on July 7th.
And I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He presumably has indicated that he had O'Doul's. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That's correct, Your Honor.
Then why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No.
I had O'Doul's.
Are
but
you
I had
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got
the story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had duels. To get to the level that you were at, you would have had to have 25 duels in an hour.
No, I didn't have
in
that.
order to reach that level.
Sure.
And could not have used the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't even, you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
In regarding the probable cause contract, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders. I
Well,
understand.
I don't think he's gonna have a choice on that, quite frankly, Mr.
Yeah.
Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really?
He's here.
No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he is asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have some concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. His scandal, I think it's just a couple of years. We would note that in this case, he allegedly was found not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I do.
The way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded. Court calls case people versus Leilani Smith. I know. So this is how it works, Ms. Smith. I'm gonna stare at that side until somebody moves.
That is, yep, Stephanie Cannon.
And we knew it would be her, so.
On behalf.
So it's okay. It's okay. She just decided she didn't want to get up.
Nope, I love being here, Your Honor.
And we love having you here just as much. All right.
So we're just asking for a 2-week adjournment to try and mitigate this a little bit.
Probable cause conference, July 31st, 2025,
Thank you, Your Honor.
9 a.m. Bond will continue. Court does call the case of the people versus Tiffany Pryor.
Andrew Tripp is agreeing on behalf of people, Your Honor.
Yes, Your Honor, please, this honorable court, Brandon Bird on behalf of Tiffany Pryor. Ms. Pryor, can you please state your full name for the record?
Thank you.
I'd like to set this matter for exam, Your Honor.
Discovery is complete.
It is, Your Honor.
People have their witnesses available the 22nd. No. Because I'm just that way today. What do you mean you know? I think I've been exceedingly patient today.
Fine, 22nd.
It stops now. Fine. Okay, what's that, the 29th? All right, fine. Preliminary, any objection from the defense?
No objection, Your Honor.
Preliminary examination, July 29th, 2025, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Oh, look there. Dewey and Louie. Court calls the case. People versus Andre Williams.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon again, Your Honor. Brandon Bird on behalf of Andre Williams. Mr. Williams, can you please state your full name for the record?
Andre Williams.
Thank you. And you're requesting an adjournment.
Yes, Your Honor.
Probable cause conference will be adjourned July 31st, 2025. Bond continued.
Thank you, Your Honor.
Yeah.
The honorable court, have a great day.
You do the same.
Thank you.
Court calls case people versus David Leland.
People, Your Honor. Good afternoon, Your Honor. Dan Guerin on behalf of Mr. Leland. David D. Leland.
Thank you.
Your Honor, I'm asking for an adjourned probable cause conference.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls case people versus Adam Barrage.
Ready, Your Honor. And Your Honor, Joe Simon on behalf of Mr. Barry. State your name, man.
Adam Barry.
All right.
Your Honor, we need to make one little amendment to that. Since it's an HYTA plea, it should be, the box should have been checked guilty, not nolo, and that's something I should have caught.
It's a guilty plea. Gotcha. Because I didn't have a police report, so. So I plea form that indicates that the defendant will be pleading guilty to 2 charges, added counts 3 and 4. Added count 3 of breaking and entering without owner's permission, the 90-day offense, and also count 4, use of a controlled substance, the 1-year offense. Upon a successful plea to those charges, counts 1 and 2 would be dismissed, and that there's a sentence agreement of treatment of defendant's pleas under the Home Truthful Training Act. Although I can't bind the court, I do see the agreement. All right. That's the court's full understanding.
Yes, Your Honor.
And that's accurate, Your Honor, yes.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Adam Barry.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
Yes, Your Honor.
All right. So first of all, this court's understanding that you're going to be pleading guilty to the charge of breaking and entering without or entry without owner's permission. That's a misdemeanor punishable, 90 days, 90 days in jail, $500 fine plus court cost. Do you understand that, sir?
Yes, Your Honor.
Also, it's this court's understanding you'll be pleading guilty to an added count 4 of use of a controlled substance. That is a misdemeanor punishable by up to 1 year in jail, $1,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
To the charge of breaking and entering or entry without owner's permission, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right, you signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are a part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and also because you believe that you're guilty of these offenses?
Yes, Your Honor.
January 31st, 2025, at the location of 404 Lincoln Court in the city of Chelsea, Washington County, state of Michigan, did you have cocaine in your possession?
Yes, Your Honor.
All right. Had you used it?
Yes, Your Honor.
Did you know what you were using was cocaine?
Yes, Your Honor.
All right. And on that same date and at that same location, had you entered that dwelling or that building?
Yes, Your Honor.
Did you have ownership interest in that building?
No, Your Honor.
All right. Did you have the permission of the owner to enter that building?
No, Your Honor.
You did. All right. Sir, if I accept your plea, I do have to advise you that any evaluation or sentence agreement in this case, if you commit misconduct as defined by the Michigan court rules, that the court is not bound by any of that evaluation or that sentence agreement. You understand that?
Yes, Your Honor.
And you understand also that if you commit that misconduct, that you could not also at that point waive your or withdraw your plea.
Yes, Your Honor.
Understand that, sir. All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
September 22nd, 2025 at 9 a.m.
September 22nd, 2025, 9 a.m. before Judge Freshour.
Yes.
Bond will continue.
Your Honor, regarding bond, one request. My client's been testing at community corrections weekly since his arraignment in early June without incident. This disposition enabled him to keep a job offer in northern Michigan. He's starting his career Monday, and he's going to be relocated.
In northern Michigan?
Yeah, Traverse City area. And community corrections said that
it's cold there. Go ahead. I'm sorry.
That if his testing requirement is to continue, he will not be able to get here, so that he would have to have authorization from this court to find someplace local.
So you're asking that he's able to test in, when is he heading up?
I'm heading up this Sunday.
Sunday? Any objection from the people?
It's not an objection.
Defendant may test in northern Michigan. I'd suggest that you arrange that with community corrections to find a suitable facility in the area. All right.
Thank you, Your Honor.
Thank you.
Wait with your. Okay. Thank you.
Board Justice is Norwin Rouse.
Ready?
Alexander, on behalf of the people, Your Honor.
And Your Honor, Joe Simon on behalf of Mr. Rouse. No one state your name.
Norwin Rouse.
Question and adjournment. Gotcha. Or how much time will that?
Your Honor, we have 2 or 3 weeks.
Your Honor, if the court is going to set the 31st, I can be here, but in the morning only, and I know that you don't like to do that. Otherwise, I'd request a different date. If you can do them in the.
Did I say I didn't like to do?
Well, if you.
Or is he making a presumption?
I made a presumption.
It's Ann that doesn't like to do
In the,
22nd.
Will that work? for you?
I'll make that happen. Is that enough time, Alan? You think?
Yeah.
Great, great.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. That will, so that you know on that date, Mr. Simon, that will be in the morning.
In the morning.
Because at some point, bond will continue.
That's a 2. Okay. I'll write you a note. You don't need to, only if you want to.
Court does call the case of the people versus Hannah Smith Sealy.
And Your Honor, Joe Simon, on behalf of Miss Seeley, state your name, Hannah.
Hannah Smith-Sealy.
Thank you.
My client, Your Honor, we adjourned to see if she'd be screened and accepted in the 15th District Court Sobriety Court. That happened.
That happened.
She's screened, she is accepted. The parties are not quite finalized with the exact plea that she's going to be rendering. We're asking for a brief adjournment.
All right. Will the 22nd be enough time for you guys to figure that out, or you want something after?
That's just a tough day for me personally, so.
Yeah, just wait for my day.
Pardon?
I will have no sympathy for that.
I know.
Second is going to be painful for me.
I'm
I'm usually very sympathetic to you, Mr. Simon.
I appreciate that very much, Your Honor. More than you know. If we could do the morning of the 31st or the very next available, either way.
Sorry, could you ask me that again?
August 7th.
Yeah, that's probably smartest.
Thank you for stepping in there, Anna. Because this was going to start spiraling downhill. August 7th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Thank you.
You do not, but if you want to write it all up. Okay. Yep.
Court does call the case, people versus Charles Tingley.
Joe Simon on behalf of Mr. Tingley. He should be online, but I don't.
I do have his camera's not on.
Where he resides, his Wi-Fi is really bad.
Mr. Tingley?
Charles Tingley.
Okay,
I'm
there he
Charles
is.
Tingley.
All right, what are we doing?
This time, Your Honor, people are requesting an adjournment.
All right.
So I believe, likely set this for the 22nd. So just you know, Mr. Simon will be here.
Will that be enough time to get, he said the 22nd is a bad date, not that we're accommodating Mr. Simon. But I can do that date or the 7th or the 31st, whichever suits the parties. You want to just do the 7th?
It would be best for me. Thank you, Your Honor.
Probable cause conference, August 7th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue. Thank you. Thank you, Mr. Tingley.
Thank you, Your Honor.
Court does call the case of the people versus Adrien Brazwell. Is that it for you, Mr. Simon?
I had one more, Your Honor.
Did you?
Maybe, nope, I'm sorry, Your Honor. I did transport Mr. Eastville. Maybe that counts in my count. The one that, I'm just kidding. No, I'm just kidding. No, the other one was dismissed. So thank you. Thank you. Thank you.
Could you pull the car around?
Wow.
Good afternoon, Your Honor. Chris Eastville appearing on behalf of with Adrien Brazwell. Mr. Brazwell, would you unmute and state your name for the record?
Adrien Brazwell.
You got him? You got him? Okay. All right.
Your Honor, Mr. Duffy and I are still working on the case. We need some discovery and time. I know based on my schedule, if
Told you.
I just gotta come
Yeah,
out of the
I try
block.
to be nice to one person and somebody else steps in.
I know.
I know. I feel bad about this.
Yeah, I'm sure you do.
I can tell. We are hoping, I have two cases up today, Your Honor. We're hoping to put them both on August 7th if possible. Any objection from the people that Mr. Eastope has picked his date?
I object because I specifically to say we're seeking a longer adjournment. I say numbers.
Wow, and you just said.
I was just looking for court efficiency. That's. Probable cause conference, August 7th, 2025, 9 a.m. Bond will continue. All right, Mr. Brazwell, I'll be in touch. Thank you, Your Honor.
Thanks.
That was a good look on Eastope's face as he just looked at my can't say it. He's right. He told me not to. Court then calls the case of the people versus Jamie Velobos. Panate?
Alexander, on behalf of the people, Your Honor.
Chris Eastope on behalf of Mr. Velobos Panate, Your Honor. And you're requesting an adjournment. You want it on this. Any objection?
No, Your Honor.
She's so nice. They are. It's unbelievable.
You said they are? No, I just
was
talking about Ally.
Oh, sorry. Just Ally.
The rest have issues.
All right, August 7th, 2025, 9 a.m. Bond continue. Thank you very much. And Mr. Villalobos is present. He's present. Yeah. Thank you. Thank you. Let's call the case. People versus Ray Namo.
Good afternoon, Judge Patrick Nineheist, P76343 on behalf of Mr. Gamo. Would you please state your name for the court?
Ray Namo.
Thank you.
Judge, discovery's been complete, and we're just asking you to schedule us for an exam.
People, other witnesses available the 22nd.
Can I request a morning time just because I have stuff in the afternoon? I don't know how.
You see what he did? He sat over there real quiet.
Yeah.
Paying attention to all those people. And now thinks he can just, right?
Well, Judge, I already tripped your clerk. And that was my fault.
Did you push her?
I distracted her enough
You
to.
push? No, are you okay? Huh?
I didn't even fall at this trip.
He did that?
I did just.
Didn't he?
Yeah.
I was distracting her. I take
Mr. Allen.
I already told you.
No.
I already told her I took full responsibility for that.
I was about.
You'll get a morning time.
Okay,
So
thank you.
here's what
And can I
I'll do.
request the same prosecutor because he's been so nice to work with?
No.
Okay.
They send a whole other evil bunch.
No, I didn't say it like that.
Wow. Okay, somebody took offense.
And I don't know her.
Preliminary examination will be set July 22nd, 2025, 9 a.m. That is before Judge Barr.
Judge Barr or Judge
Judge
Frasier?
Barr.
Okay.
I'll let him know you don't know his name.
Oh.
Bond continued.
Just to make sure it's this courtroom or this courthouse?
It's in this courthouse.
Okay, thank you.
He'll be, I'm on that day, so he'll be next door in courtroom B.
Okay, thank you so much, Judge. I just want to make sure I go to the right place.
Thank you, Your Honor.
Thank you, sir. Court does call the case, People versus Jacqueline Buckle.
Good afternoon, Your Honor.
Good afternoon, Your Honor. Paul Stablin appearing on behalf and with Ms. Wachel, who is standing to my right.
It's Wachel.
Wait.
Your name?
Jacqueline Rachel.
Thank you. All right. What are we doing on this case?
Your Honor, I've had discussions with Mr. Cook
How'd that
about.
go? No, I'm kidding. Go ahead.
It went great.
Oh, it did? Okay.
In regards to some outstanding discovery, the last time we were before the court on Zoom,
Yes.
we had discussed that the prosecution does not yet have the cell phone extraction, which I wanted the opportunity to review before advising Ms. Wachel as to how to proceed.
Right. And that usually takes a lot of time.
So I got in contact with the OIC. He informed me that they would be able to create a copy of that flash drive and prepare it by next week. They already have the phone done, it's on a flash drive.
Got it.
They just need to make copies for us.
Got it. Okay, well, that's further along than where I thought we'd be. Okay, and that would be next week, then that would get to you, and then if I set it for the 31st, will that be enough time for you, counsel, or you need?
It will be, Judge, can I lock it in for the afternoon? Because I've been listening to the dates.
See what he did? He was sitting back there and he did that, and he was really such a nice guy on Zoom. And then he knows how much that irritates me.
Oh.
People do that. He just didn't.
I have to.
He just didn't care. Just didn't care. See, and this is, I'm sensitive. Aren't I?
I apologize, Your Honor.
I'm not accepting it. No. You will be in the afternoon in any event as private counsel.
Thank you very much, Your Honor.
You'll be good. So probable cause conference, July 31st, 2025. I set it at 9 a.m., but you'll be in the afternoon.
Thank you very much.
All right, thank you. Bond will continue. Thank you. Okay, any more trouble winning pause or is that it?
You've got a 3 o'clock block.
And we have a brand new assistant prosecuting attorney. Haven't met her yet. I understand she's here and has hit the ground running. Okay, I guess I'm gonna get busy here. Thank you all. To everybody, let's get started. Oh, Mr. Knopfinger, you got number 1, so you're.
Oh, boy.
Your badge says.
Oh, yeah.
You're number 1.
It's a coincidence.
Sorry, Judge, we are all over today.
Yes,
This is
good
Angela
afternoon.
Canfield, our
Good
newest
afternoon.
APA. Good afternoon. So I wanted to introduce her, and she's handling us. I'm running upstairs, and if you need anything, grab me, all right?
All right, thank you.
She's ready to go. I'm very excited.
Okay, we'll try not to.
Don't scare her away,
Squash
okay?
this
Really going to her.
expectation. Ms. Canfield, it's nice to meet you. I know of you.
You as well, Your Honor.
You have a very fine reputation. I'd like to.
May I approach?
Yes.
Good afternoon.
you.
Yes, I think that back when you maybe were in office, I might have done a special prosecutor case here when I was working in Allegan County.
Allegan County, I forgot that one. I may have also had you as a student at basic prosecutor training.
Yes, that sounds
30
about right.
plus years ago, so.
Mhm.
Well, thank you. Welcome to St. Joe County. All right, let's start with Kayla Brienne Coffey. Good afternoon.
Good afternoon.
You're Kayla Brienne Coffey.
Yes, sorry, Your Honor.
You're fine. You got charged with domestic assault. It's alleged that you assaulted someone you had a dating relationship with, Mr. Vance Long. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Apparently, the prosecutors agreed to reduce that to a charge called disturbing the peace. Disturbing the peace is a lesser charge. It's punishable by up to 90 days in jail and a fine of up to $500. It doesn't carry a firearm restriction and doesn't show as an assaultive offense. Assistant Prosecuting Attorney Angela Camfield is here on behalf of the people. Ms. Camfield, is that your understanding of the plea agreement?
It is, Your Honor.
Ms. Coffey, did you hear me when I went through the advice of rights just a moment ago?
Yes, Your Honor.
Do you understand you're giving those rights up by entering this plea?
Yes, Your Honor.
Anyone promise you anything to get you to plead to this
No,
or threaten you?
no.
All right, you and Mr. Long, were you living together at the North Lincoln address or was that his address?
No, it was his address.
But-
Sorry.
But you don't live there.
No anymore.
All right, you got in an argument and you bit him. Do you remember what you were arguing about?
Yeah. He was upset about something in my phone.
I was talking about a quarter of our domestic violence cases start with somebody looking in somebody else's phone. So he was upset. You got into a further argument and then at some point you bit him.
Yes, Your Honor.
All right. Are you and he still in a relationship together?
No, Your Honor.
How old are you?
19.
What do you do, ma'am?
I just work at McDonald's.
Well, don't say just. I like to go to McDonald's. And I'm glad there's someone there when I come. Oh, are you working part-time?
No, I'm full-time. I'm on overnights and second shift.
Bless your heart. Those are really crappy hours. But at 12:10, that's good to know there's somebody there if you can't live without a hamburger.
Yeah, I'm usually there. Don't worry.
Well, I'm usually in bed by that time, so you won't see me, but we get a number of drunk driving cases going through the drive-through late at night at McDonald's.
We have had to call the cops.
Yes, it happens quite often. Are you on probation or parole anywhere?
No, sir.
Have you been convicted of anything like this before?
No, Your Honor.
I was in Chicago a few weeks ago and I gave my grandson a bath and he had a great big bite mark on his back. A little boy in preschool bit him. That left a nasty set of impressions. So biting somebody is a big deal. He had a bite mark on his chest and his arm. And I'm not sure what actually went back and forth here, but the prosecutor knows more about this than I do. They've elected to reduce this to a disturbing the peace, which almost always results in a fine only and takes it out of the crime victims' rights arena. So you spent a night in jail. How was that?
It wasn't so bad.
Oh, well, it's supposed to be bad. We don't want you to come back. Would you like to go back?
No, thank you.
All right. All right, my kid said I should put my hair in that color, but I didn't ever get around to doing it. My hope is you don't come back for this or other stuff. Because this is one night in jail, which hopefully will be enough to last you. There's a $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee, $150 attorney fee, which is $350. Can you pay that within 30 days?
Yes, Your Honor.
I'll make it due by the end of August 29. All right. Maybe I'll see you at McDonald's. I'd like to not see you in here anymore, all right?
All right, wonderful.
All right, you're good to go.
Sorry.
Jonathan Dentler, let's see if we can get that one done before the translator comes in. Good afternoon, Mr. Dentler. Mr. Dentler, in your case, it's alleged that on or about, no one talks like that, but lawyers, basically on January 11th, that you assaulted Diana Holst, someone you had a resident shared a household. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500, but also prohibit you from using or possessing a firearm. The complainant in this case is your mother, and she resided in the same house as you did. So that brings it within the purview of the domestic violence statute. Someone is charged with domestic violence. We have a special statute which allows the court to put the defendant on probation and allows the court to defer sentence in the matter or defer the conviction if you successfully complete the probation. Now, I can only do this unless the prosecutor consents. And my understanding, Ms. Camfield, is the prosecutor's plea offer here is plea to domestic violence and no objection to the deferral. Is that correct?
Yes, it is accurate, Your Honor.
Ms. Ives, is that your understanding as well?
Yes, Your Honor.
Mr. Dentler, did you hear me go through the advice of rights?
Yes, sir.
We're in there. Did you understand those same rights apply to you?
Yes, sir.
You'll be giving those up by entering this plea?
Yes, sir.
Anybody threaten you to get you to plead to this?
No, sir.
Or promise you anything?
No, sir.
All right, as I recall from reading the affidavit in this case, you're upset with your mother because you believed that she had called protective services about you and your children. That made you angry, is that correct?
It was about my wife. Yes, sir.
All right. So did you end up putting your hands on your mother?
We pushed and shoved each other. Yes, sir.
She said you hit her, grabbed her by the throat, and she fell over a box of toys.
No,
That sounded.
sir, I did push her. I did push her, but no, no, right.
All right.
I'd also like to add, Your Honor, in that report, there was reports that she was asked to see medical treatment and denied it.
Okay. This is a crime victim case, and the law requires that I set this matter for sentencing. It is 10 days out from today. The prosecutor's victim staff is here. We had any input from this complainant, from the victim?
We've talked to his mother multiple times. She was wanting him to take the plea offer originally. She wants to be able to see her son and see her grandkids.
All right, fair enough. Well,
I'd like
let's.
to also add, Judge, on the PPO order. I know my mom told me that he had signed that it's been lifted.
The PPO has been lifted?
Yes, sir.
I got so many in the last 10 days. I don't disbelieve. I think I said there's already a domestic violence case in place with no contact provisions. So I think that's what I did, but I'll confirm that. All right, the law requires that I set this out at least 10 days to give time for the victim to provide input. The problem is I'm going to be on a little trip. Here's our translator. Let's go with the 13th at 10:30. Mr. Dentler, where are you staying right now?
502 Wenzel.
And your mom is staying where?
703 Colossal Road in Bronson.
Yeah, you'd like to all get where you can see each other. So that's why I didn't want to go any farther than this.
Judge, the piece of paper that my mom received, she has showed me, states that it's been lifted completely. That's that there's nothing like that. Me and her can see each other. That was signed by you, sir.
Let me take a look. There's two things going on. There was the PPO and then there was the no contact order. And I don't think I
This is a
Lifted no
bond
contact.
condition, which is different. That's different.
Let's take a look.
That's what I'm confused about here, like there's.
All right, let me,
on both sides.
bond conditions were set by Magistrate Autumn Kiefer. No contact with Diana Holst until further order of the court. So the PPO may have been lifted, but the bond conditions not, so they're still in effect. So we're gonna have to just keep it together for a month, and I will see you on August 13th. All right, Mr. Dentler, you're good to go. What I envision, Mr. Dentler, is to put you in the domestic violence treatment class. And if you successfully complete the class, the charge could be made non-public. So you're gonna have some work to do, but I think you could do it. Han?
Yes, Your Honor, I was going to be asking for another final pretrial conference on this matter. There's a voluminous amount of paperwork and then some additional paperwork that I need to compile and provide to the prosecutor.
All right, let's address that case. Maria Isabel Han. File 25728 SM. I met Ms. Han when she was here at her arraignment and at the attorney pretrial. The allegation is domestic violence, 2 counts. The complainant is Noah Han and a minor. My understanding was Mr. Han did not wish to proceed with charges, but I don't know all the nuance. You're asking for another final pretrial?
Yes, Your Honor.
Ms. Camfield, you haven't been here long to know what's what. Do you have any objection to that?
I do not have an objection to that at this point, Your Honor, but I would note there are 2 separate counts, one including an alleged assault against a child.
Yes.
So that's one of the reasons for the stances of the prosecution to proceed at this point. But we do have discovery that we still need to exchange, so I would agree with that.
All right, let's pick a date. Laura, do we have any Thursday pretrial dates coming up with Rhonda Ives scheduled already to be here? I don't see any in the near future. All right. How would you be for Thursday, August 14th?
Thursday, I'm sorry, what did you say?
August 14th.
The afternoon, Your Honor?
Yes, 2 o'clock.
The afternoon is fine. I have to run an exam in the morning.
On a third, in Branch County.
Branch County, yeah.
I've set continued LPT for Thursday, August 14th, 2025 at 2 o'clock.
And then, Your Honor, my client has just informed me she's had some prior arranged plans to go to Tennessee with a cousin who's visiting from Spain that first week of August. I just want
Because
to.
of Cinquez, because I got so many of them. I see that. All right. Laura tells me maybe I shouldn't do that. So we'll
Okay.
come back to your request here in a minute.
Okay.
Ugh.
The following week on the 21st, I am.
That's the judicial conference.
Oh.
I'm gonna set it on the 14th anyway. I got a lot of time blocked out for Cinquez furlough, but she doesn't need 2 hours. Thursday, August 14th. All right, I have pretty poor handwriting, but you'll get a better notice from your lawyer or the court or both, but put that on your refrigerator. We'll revisit this matter in a month.
Thank you, Your
August
Honor.
14th at 2. And we'll see what we know at that time. All right, you're free to go. Thank you for your patience.
Oh, Your Honor, just one more thing about the
Oh,
bond
yes,
condition. I just
I have
wanna,
no objection to you going to Tennessee.
I called the county clerk, Your Honor, and she said there was nothing on the bond condition, so.
They said you made fun of me when you heard I moved to Tennessee.
I would never make fun of you, Your Honor, ever.
It's from How Do You Like Me Now?
I don't even know what that is.
That's very common, so I get that a lot. People have no idea what I'm talking about. Anyway, I'll see you on August 14th. They said you made fun of me when I took off for Tennessee. All right, we sure have a lot of people here for what we have left. We have two pre-trials. Denzel, oh, they're all here on that case. Thank you, everyone. We have John Cap, and he's here. And we have Denzel Smith, and I don't know, are we ready to do Mr. Cap?
Yes.
And Luke, did you have any luck with Mr. Smith? All right. She's probably not gonna be in a position to give you what you want. You're gonna have to probably talk to Ms. Davis, but we'll see. She's only been here for 3 days. Then we have the sentencing on Ms. Stallard, and we'll get to that when we finish these. Mr. Cap, I thought you weren't gonna come back and see me anymore. That was the plan.
No, Your Honor, I'm getting older and I need to make some serious changes in my life.
I wouldn't disagree with that. Let's talk about these two cases. File 25632 ST, people for John William Cap. That charge alleges driving suspended second offense. That occurred on allegedly April 5th, and you had some open intoxicants in the vehicle, and they charge you with that. Driving suspended second is a misdemeanor. When I was a young prosecutor, it required 2 days in jail. I said on the record the other day, if everybody that got charged driving suspended second today spent 2 days in jail, we wouldn't have anybody else that would fit in the jail. We get lots of driving suspended repeat cases now, but 100 years ago was more of a serious offense. Anyway, that's punishable by up to a year in jail. A fine of up to $1,000, carries 2 points, and requires that your license be further suspended. They allege it happened at 11:49 in the morning at West Broadway and 131. They also allege that you had an open container of something commonly referred to as open intox. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $100.
Is that a city of Sturgis?
That's a city of Three Rivers ordinance charge. So one of these is state statute, one is city ordinance. I don't know why they do that. I wish they wouldn't. Ms. Camfield, is there a plea offer here?
Yes, Your Honor, there was just a plea to the charge, fines and costs. But having noted with counsel that there is an open felony matter pending potential jury trial next week, they would like to adjourn, and I'm fine with that. I actually suggested that as well to see what happens on the felony, see if we can resolve all these matters together.
Fair enough. Mr. Cap, do you have any objection to that?
No, Your
Honor. When I saw this, I was disappointed. And I wasn't making light of the fact you're tired of coming in here. Your dad comes in here with you almost every time, and now your mom's here.
He's not feeling good.
And it's like you said, you're too old for this. And you're driving suspended. You're in Three Rivers. They know you're suspended. It's like shooting fish in a barrel. You're at 131 and Millard right in front of Walgreens. Just don't. All right, but I'm certainly agreeable to adjourn this. Mr. Bush, do you know if you have any Thursday pre-trials coming?
I believe I do, Your Honor.
I don't want to drag you around the map. Let's see what we got here.
some reason I'm not getting reception in here on my.
Yeah, you have that every time. We got bunker mentality here. I didn't see you on the 7th. This is a,
We set for Friday morning.
yeah, I guess we could set it for a Friday, first of the month pre-trial, if that works for you.
That would be,
Yeah, all
I'm
right.
always here for those.
Continue to August 1st. Ms. Camfield, we have first and third Friday of the month pre-trials. You're about to experience our next one, which is this Friday. It's going to be very busy. But generally, almost all the defense attorneys are scheduled to be here Friday mornings, and so often we'll bump things to that date because they've already cleared their calendar.
Sure.
And so we got 411 cases that day. Another one won't hurt. We're going to continue for an attorney pretrial for August 1, 2025 at 8:30.
Thank you, Judge.
That's a
Thank you,
good
Your Honor.
suggestion. The first Friday of July was the 4th of July. So we bumped them to this Friday, which gave another week to put cases on there, so. Well, there are a lot. There are 72 cases of 50 separate defendants. So we'll have our work cut out for us on Friday morning. August 1st won't be that busy. All right, Mr. Cap. Keep paying on your payment plan stuff. I'll see you on August 1st. All right, Rhonda, we're back to your case. We got our last case of the day. We have an hour or more if we need it. People versus Jayla Marie Stallard. You come forward, please.
Your Honor, I would indicate just moments ago, I received an email with a restitution request of $1,250. I reviewed that with my client. My client is not objecting to that and would like to change her statement from when she did the plea as well. So.
All right. This is file number 25843FY. People versus Jayla Marie Stallard. That's you?
Yes.
You're here with your lawyer, Rhonda Ives. Also present is Assistant Prosecuting Attorney Angelique Camfield. This matter was set for sentencing today, and I spent quite a bit of time on this case yesterday, trying to understand it. The defendant was originally charged with larceny in a building, which is a felony punishable by up to 4 years imprisonment, and charged with embezzlement by an agent or trustee less than $200. Let's look at the original complaint. Yes, as a second habitual offender, she had a minor drug charge in circuit court here in San Joe County in 2018. The felony charge of larceny of building was dismissed, and the defendant pled to the embezzlement less than $200. Now the affidavit, and then I got the police report after the defendant entered a plea, indicates that these thefts took place in several different ways. Taking money out of the cash register, both the Legion's cash register and the lottery, Michigan Lottery's cash register. Some other money envelopes that came up missing, and someone entered the building with a key and went in the back door and stole money out of a jar that was on the counter, which appeared to be, it was alleged to be about $400. Miss Stallard acknowledged to me that she took the money out of the cash register, but specifically denied entering the building and taking the jar of money. So I wanted to get the video that the officers had. And with the help of the prosecutor's staff, I got it and I was able to review it. So the restitution agreed amount is $1,020.
I think it's $1,250.
That is
Okay,
correct, Your
all
Honor.
right.
And if I may also note for the record, Your Honor, there is a representative of the Legion here that would like to briefly address the court.
I see the gentleman here. They've been here through each hearing, and we'll certainly hear from them before we finish. Ms. Ives, you indicated your client wanted to change her representation of the court.
I think that she's had a lot of time to think about her statement. She's been rather sick to her stomach over her last statement because she wasn't truthful and it's really bothered her. I told her she'd be able to address the court and tell the court her feelings.
All right, give me a second here. This is the video of the person coming into the building on December 2nd. My question is that you walking in that door?
Yes.
All right. You guys have seen it, but that shows of someone pulling up in a car, coming out in a white jacket and jeans and boots, and using a key to go into the building. Then you see an arm with the same white coat, take the jar full of money, empty it of money and put it back. And she specifically denied doing that when I took her plea, but now she acknowledges that she did take that. So, Ms. Ives, where does that leave us?
Well, Your Honor, my client has indicated that she is felt horribly guilty. She has not had any legal problems for a number of years. She is ashamed of her behavior, especially because her grandfather is a veteran, and so it's impacted her significantly. She's willing to do probation. She's willing to pay the $1,250 back. She just recently got some gainful employment in Angola. She'd like an opportunity to get the restitution paid. She's hoping the court would suspend a jail sentence and allow her an opportunity to get this paid back. And she would just like to extend her deepest remorse for her behavior.
Ms. Stallard, what would you like to tell me?
I can't even face my grandpa. He would be so ashamed. And I'm sorry. And I'm just sorry.
I was seriously contemplating just giving you 93 days in jail for admitting to part of this and lying about the rest of it. It was going to become an issue of whether it was you and how much, who else took anything, and you're acknowledging that you took all of it. It isn't true that you haven't had other problems. You were charged with retail fraud last November from the Walmart store. You never paid the fine. You got defaulted on a retail fraud charge and you didn't pay it. We sent it to the 9 Mile Road address in Union City. So you were stealing stuff in November of 24. This is in December of 24. You had methamphetamine in your past, and the question always becomes, is that still what's going on here? Is
No,
that what's
sir.
driving the bus?
No, absolutely not.
Or if I gave you a drug test today, what would it show?
Just marijuana.
Autumn, I'd like to do a urine test on this defendant before we finish to see whether I'm dealing with methamphetamine. Embezzlement is, people often downplay it. I've seen cases that offend my sensibilities. Someone in Kalamazoo embezzled $100,000 from the Little League and they got probation. Somebody embezzled $350,000 from one of the Upjohn heirs, they got probation. Same lady embezzled $18,000 from the 4-H here in St. Joe County and went to jail. Embezzlement is different than theft. It's a betrayal of trust. You're placed in a position of trust and you violate the trust by stealing from the person that entrusted you. And it almost always happens more than once. So in this case, you stole from your employer multiple times, multiple ways. And I don't know how somehow that's better than just stealing a bottle of liquor from the liquor aisle at Myers. It's worse. It's a repeated violation of trust. And there were probably 6 or 7 different types of theft here over different days, pocketing cash, taking the envelopes, stealing this money jar and then lying about it, saying I'm sorry, he doesn't quite get it. So I don't know what drove you to go in there that night and steal that jar. That's why I'm asking about methamphetamine. Because something was driving your bus. What was going on?
It was Christmas time and I was just struggling and my kids, and I got them back in my life and my grandson, and it was a stupid decision. And I mean, I'm doing way better than I've ever done in my life. And my kids are back in my life. And
where you're living in Angola?
No, and how at the moment.
All right.
Because I was, like I said, I was trying to go to Missouri, but.
And at some point you can.
Right.
Are you aware of that retail fraud ticket?
I didn't know. I didn't even know about that. So.
Well, the officers gave you a ticket.
No, I don't remember ever getting a ticket for retail fraud.
Seth Chester.
Oh, it was a trespassing ticket is what
No, it was a retail fraud ticket.
What?
And we sent you information regarding pleading to the ticket and you never responded, so they entered a default.
My mail's been not coming to me. It's been going to the old address and they're not. I didn't know that.
Well, first of all, they cut you a break by not charging it as a misdemeanor. They charged it as a civil infraction. You also got some traffic tickets, which you haven't paid either.
Yes, like I said, I just started at Jed's Barbecue, that place I was telling you about, and that's my goal, is to get everything paid off.
Well, all right. This is Autumn Kiefer. She's from the probation department, and she's going to take you back in the lockup with the bailiff. We're going to do a urine sample. Go with her. This is called dead air. I heard the toilet flush. I thought that was good news, so maybe not. What are we doing?
So she is on 2 medications. One that could potentially throw a false positive for methamphetamine. It's for an ADHD medication. She does admit to the marijuana use, which she is positive for. She's also positive for methamphetamine, amphetamine. There's a very faint line for oxy, and buprenorphine is positive as well.
All right, thank you. So we are dealing with methamphetamine, which is often the
No.
pink elephant in the room. So you're denying that you're.
Yes, I am not on methamphetamine. I'm not.
All right.
But I
Well,
heard she is,
Concerta and Zoloft is what I take.
okay. Well, it's too late to do a test at the day
I mean,
reporting
I have my
center.
prescriptions. They're just not with me.
So we'll see. You lied to me about the other stuff
Right.
and now you're telling me this, so I don't know what to believe and what not to believe. Buprenorphine, what's that about?
I asked her what that was and she said that that's mental health medicine.
No, it's not. It's a opioid blocker that people take.
That's my gabapentin, and I have a prescription for that as well. I've been taking that at night to sleep.
Well, we'll find out what we got. So, all right, I have a suspicion that there's an underlying drug addiction issue, which is compelling this behavior, particularly the theft of the big jar of money. So having said all that, Ms. Canfield, you're new to the staff here, but you've had a chance to look at this and you've had plenty of prosecution experience. What's your thought here?
Your Honor, I would also like to hear from the representative,
Right.
but as
Yeah,
far as.
well, let's do that first. We'll let
Yes,
who's
thank
gonna
you.
speak on behalf of the Legion?
I'll stand up.
Good afternoon, sir. Of course, I know you, but would you state your name for the record, please?
William Thompson.
And what's your connection to the American Legion?
I am the past commander. I've been with the Legion for several years.
And you've been at every one of these court proceedings?
Yes.
And are you here to speak on behalf of your chapter and the members of your group?
Yes, I am.
All right, what would you like the court to know?
I realize this is a small amount of money, but I hope you will realize that you have taken not only from this merit post, but from every veteran in the area. This post supports an honors team that does military honors at funerals from Montville to Sherwood to the middle of Kalamazoo. And there is never a charge for any of our services. Thank you, Your Honor, for allowing me to speak.
You also provide scholarships to high school students from your post as well?
No, that's the VFW.
VFW, so I've often
I
conflated
also
those.
represent the VFW.
Yes, all right, so, all right. Thank you. Excuse me. The Legion has been a victim of embezzlement at least 3 times since I've been here. That's been a long time. Many, many years ago, the treasurer embezzled about $10,000. And a lot of those members have passed. This was 35 years ago. Then more recently, during Doug Fisher's administration in the prosecutor's office, there was another substantial embezzlement from the Legion. This one wasn't huge, if we're talking about $1,250, but it was executed on multiple occasions in multiple ways. And as often happens, eventually it all catches up, which it did here. So, Ms. Camfield, what's your input here?
Well, Your Honor, I share the court's concern. I know oftentimes positive drug tests can be for prescription medication. However, we don't have those prescriptions with us here today. And if that was going to be a claim, I would presume that they might have been at least provided to her counsel if she knew there was a likelihood that she could be drug tested. I do also know that theft from employers often as a result of a drug concern and addiction by the defendant. So in this particular situation, I do agree with the court that I think that might be part of the driving force. I also know as a mother with children that wanting to get them holiday gifts could also be a very legitimate explanation, certainly not an excuse, but an explanation of the defendant. As she stated, she's probably being honest with respect to that. But I am concerned about her former dishonesty with the court and only wanting to come clean about the theft of the jar of money today, as she knew the court had the video. And then being dishonest about what may show up in her drug test. So I do think that probation and restitution is appropriate with respect to any potential jail. That's a tough one because you want her to be maintaining her employment to pay back the restitution. And frankly, this was an offense that affected serving members and former serving members of the community. So I think a pretty hefty community service sanction would be appropriate. In addition to perhaps some, I'll leave it to the court's discretion of whether there's any jail and it's suspended or not. But I do really feel that community service would be appropriate. If she does feel as bad as she tells the court, then she can give back to the community in a fashion that doesn't involve her handling money.
There's another factor here. Nobody's been around long enough to remember this. I was the prosecutor for a number of years before I came to the bench, and we had lots of embezzlement cases from young women. And we learned that there is a connection between childhood trauma and embezzlement. So I started a women's embezzlement treatment program, which I was very proud of. And then it expanded to men and women. It was called the Embezzlers Treatment Program. And we had check passers and embezzlers and repeat retail fraud people, but mostly embezzlers. There's a connection between embezzlement and childhood trauma that most people don't understand. I think that may be part of what's going on here too. And the program died on the vine because the circuit court never used it anymore. And I regret its passing. It was excellent. And if I had it, I'd order you into it. I'm going to do a 12-month probation, which means you could be discharged at the end of 6 months if you do a good job on it. What was the plea to? Make sure I got my notes straight.
It was an embezzlement less than $200, Your Honor.
Yeah, I wanted to make sure it was embezzlement rather than larceny. She also took care of her insurance charge when she was in here. Yes, embezzlement less than $200. That doesn't look good on a record when an employer wants to hire you and the first thing that shows up is an embezzlement. They put you on the bottom of the pile. And maybe they ought to know. I'm going to order restitution to the American Legion. The amount of $1,250. That's the paramount concern here. Probation is $480. There's a $150 attorney fee. state minimum fee of $50 and crime victims' rights fee of $75. So let's add that up. 125 plus 150 plus 480 plus 1250. $2,005. If you do this in 6 months, you could save $240. You got arrested on June 5th and you bonded out on June 6th, so you have 1 day of credit. Or the 91 days jail credit of 1, leaving 90 days to serve. Of the 90 days, 83 are deferred. You're going to jail right now for 7 days. I don't know what that's going to do to your employment. I'm going to hang the rest of this over your head. I would like to get a drug test from a proper testing service to see what's in your system. It's a condition of your probation that you not use any drugs or alcohol and take a test as directed by any probation agent. If I knew I had a drug issue, for sure, I'd put drug treatment as a component of this. Right now, you're indicating that there isn't an issue. It's legal to smoke marijuana as an adult in Michigan for recreational purposes. But while you're on this probation, you can't use marijuana or drink any alcohol, or certainly take any other controlled substances. You can take any prescriptions that are prescribed. I may ask to facilitate transporting you to the day reporting center tomorrow for a full 17 panel test to see what's in there. And then I can fashion the probation. But you've got a previous criminal record. You've got a retail fraud that you've ignored. We have multiple thefts in a position of trust, and you lied to me about it and came clean today, which I do appreciate. That's a difference between 7 days and 93 days, but you deserve a jail sentence. You deserve it right now to make some impact. I'm going to check embezzler's group, see if there's some vestige of it somewhere. I don't want to go into all that on the live feed with you, but I think there's an underlying component of childhood trauma, which is in this mix as well.
I am gonna lose my job.
That's on you. That's not my fault. That's your fault. You go with the court officer. All right. When you get out of jail, you're going to be on probation. So you need to come see the probation department unless they come out and see you at the jail. And I'm going to see if I can facilitate a proper full urine test tomorrow to see what we're dealing with. All right. You go with the court officer. All right, that completes our sentence, our afternoon, and our day. Ms. Canfield, it was nice to meet you, and I'd like to get to know you more as we start to work together. For everybody else that's here, thank you for your patience.